Yeah, that was fair.
Good afternoon, everyone. This is September 29th, a planning public meeting, and I want to welcome you. We're holding this meeting to learn about a proposal to amend the land use planning permissions applying to certain lands in the municipality of Meaford. Council is legally required to make decisions that conform to the county and Meaford official plans. Our policies encourage us to reach out to community stakeholders to gather information. We have a variety of legal tools available to us that we can apply to development that help us manage change in a positive manner, which is minimal in impact, or at least as much as possible. And your insights can be part of what informs our direction. Those in attendance for today's meeting will have an opportunity to speak in person or remotely if pre-registered through Zoom. This meeting is not structured as a dialogue between speakers and the applicant. However, the applicant may take the opportunity to respond to comments toward the end of the meeting if they wish. Note that in many cases, formulating responses may require staff to carry out research after the meeting on the matters raised, and then provide answers following the meeting or through their report to council. So I'll now call today's public meeting to order. It's a public meeting to consider a zoning bylaw amendment for lands at 121 Eagle Ridge Drive in Meaford. This meeting is a mandatory part of the planning process, which has been set out by the Planning Act. Based on the rules of the Act, there must be at least 20 days' notice given to residents within 120 meters of the property. Notice of the zoning bylaw amendment was issued on September 9th, 2025, giving the required 20 days' notice. So we'll get started, and I'm going to first ask Denise McCarl, Manager of Planning Services for the Municipality of Meaford, to give us a brief presentation about this application and to provide us with any public or agency comments that have been received to date. Denise?
Thank you, Mr. Mayor. So I am sitting in for Michael. He's away today, and so please go easy on me with your questions. We do have the agent for the application here as well to answer any questions, and I'll do my absolute best to go through the presentation with some good detail here. So as noted, this is a zoning bylaw amendment public meeting. The purpose of this meeting is to hear a presentation from staff with a few details about the application and to provide a public forum for comments on the proposal. So this application is relating to 121 Eagle Ridge Drive in Meaford. It is a vacant parcel of land, and surrounding land uses include primarily residential uses and some agricultural uses to the south. And of course, you could see Georgian Bay to the north there. This is a waterfront property. The current zoning of the property restricts development on the parcel to a very specific established building envelope. And the property owners would like to modify the building envelope to safely accommodate a new home and associated garage, and of course their septic system, et cetera. And to this end, the application retained a consultant, so a geotechnical engineering firm, to do a slope stability study. The reason for that slope stability study is that the building envelope related very specifically to some natural features on the site, generally mostly the slope, I would say, but there are other features as well. So the waterfront is one, and then of course there's quite a steep slope on the site. So the slope stability study was seeking to demonstrate that the building envelope could be increased in size as requested to accommodate a proposed development. So this is a really hard to see sketch when you're looking at it from here. Hopefully, if anyone really wanted to see a bigger version, we could happily send one. But if you could see in red, that's approximately where the current building envelope is. So it's very close to the street. This picture is turned. So on the left-hand side is Georgian Bay. And on the right-hand side is basically where the road is. And in the center there is where the development envelope proposed and existing is. So the red area is what's currently approved. And I think it's outlined in blue there, or purpley blue. is where they're proposing to build in addition to that red envelope. Part of the house would be in that new blue area. And that would accommodate the garage, the septic system, and the house. So now we're back to the way the normal maps would be. So you can see that right now, the County of Gray official plan shows a significant amount of hazard lands on the property and sort of that inland lakes and shoreland designation. And then Meaford's official plan also has that hazard area with some shoreline environmental or some shoreline area shown in that orange. Noting that these policies and these designations came after the original approval for this site and the subdivision and subdivision agreement and zoning that initially approved this development. Which is why in the zoning bylaw, we see that RLS-225 zone. So that's the residential limited services and exception 225. It restricts the yard setbacks and things like related to the development envelope and gives that weird schedule that Meaford seems to have, which is this D schedule series in addition to the normal mapping. This gives specific building envelopes to properties which wouldn't be able to be shown in your normal zoning map. So that D3 schedule is what shows the building envelope. And it's pretty old, so that's why it looks like this. The original zoning, my understanding is it was passed in around 2004 when the original subdivision was being reviewed. And it was subject to some amendments after that and then was incorporated into our newer zoning bylaw, the 60-2009 that we now use. So you can kind of see on this one, Michael's been good enough to circle an area of the lot where we're kind of looking at today, which is number 6. And you can see that dark area there is down that's very close to the road is the only area that's right now approved for development. And I believe looking back through that subdivision file, there weren't things like slope stability studies done for this parcel back in that time at that time. So this is probably why the zoning envelope, the building envelope was created as it is. So this slide always just lets us know, and anybody watching from home, since we don't have a lot of folks here today to attend this meeting, but if they're watching from home, they can kind of see where we are in the process, which is we're at the public meeting stage. Following the public meeting, staff will complete our review and then we'll bring recommendations back to council. Then council will make a decision and then there'll be the appeal period. And then if there are no appeals on that decision, then the decision will be final. And I don't know if we want to leave this up just in case the agent for this application might want to speak to any of these drawings or the map or anything like that, or if council has any questions on it. But I'll just leave it here in case we do want to go back to it. And I'll just go through briefly the comments we've received to date. So we don't have any public comments on this application, but we did receive 3 agency comments. So the first was the County of Gray just noted that they're streamlining their development review process for zoning bylaw amendments, and therefore a formal policy review was not completed. So they basically didn't do a formal policy review on this application as there were no specific county related matters that they needed to review. So they didn't identify any concerns or issues. The Historic Saugeen Métis Lands, Waters, and Consultation Department reviewed the application and recommends that the application not be approved. The existing limit of development should be maintained in order to protect the shoreline. The Gray Sauble Conservation Authority reviewed the slope stability study and the other documents circulated with the submission and have no concerns with the plan to place fill and lessen the slope for development. A permit is required for the new proposed dwelling and grading and drainage site works. And so they support this zoning amendment provided the appropriate GSEA permits are submitted for these works. And that sums up the comments we received. I have a few other kind of notes just in case we have any other questions that come up that I can refer to. But otherwise, that concludes my presentation.
Thank you very much, Denise. Is the applicant or their agent present? Ron, if you would like to speak, if you just give us your name
Yes.
for the record. Thanks.
Yeah, thank you. My name is Ron Davidson. I'm a planning consultant, and I represent the owners, the Hoopers, who obviously aren't here today. I shall be brief, very brief. As Denise, who's ever controlling the slides, if you could go back to the zoning. Thanks, Denise. Even back to the actual, that one there. Sorry. Yeah, you'll see that the property is in fact zoned residential. And that's what you'd call, I guess, Schedule A to your zoning bylaw. When this subdivision was being approved a number of years ago, a zoning bylaw, a second schedule was prepared. It's not very common. It happens, but it's not very common where council or whoever drafted the bylaw, certainly not council, where they took the building envelope, and that's the next slide, Denise, or the next one after that, please. They took the building envelope and incorporated that right into the zoning bylaw. Again, not very common, but you see that from time to time. There we go. And as you can see, lot 6 is one we're dealing with today, but lot 5 to the west has also had a very small building envelope. And a couple of years ago, the owners of that property went through the identical process that we're going through right now. I was part of that. How that ended is it was approved. Council supported the zoning bylaw amendments, and there's a big house on there, or a nice, beautiful house there today. And now the owners of lot 6 wish to do the same. It is all technical, it's all engineering. And as Denise referred to, there was a slope stability study done and a site plan prepared showing how development can occur on the property in accordance with basically good engineering standards and provincial standards. And as you heard, the Conservation Authority has given it their blessing. Even though council is the approval authority here, you'd be hanging your hat, if I may say that, on the Conservation Authority's comments. And like you heard, they have, as of Friday, they are on board. So that's great. I don't really have much more to say. I heard the comment from Métis. I mean, I'm not sure really what that's based on. Again, it's from an engineering perspective. Again, the Conservation Authority's on board. All the necessary work has been done. I respectfully would suggest that there's really no basis to have this application refused. Thank you. Those are my comments.
Thank you very much, Ron. There have been no pre-registrations to speak in person at this meeting by members of the public. And I see no one in the audience to speak, and I know of no one who is online to speak. What about members of council? Someone wish to speak? Councillor Forder.
Thank you, Mr. Mayor, and through you. And Ron, thank you very much for being here today. Just a couple questions. It doesn't mention specifically, but would the build be compliant with the shoreline setback? Is it 30 meters, Denise? I just want to make sure that it would be compliant with that. Or is there a reduced buffer being requested for this bill?
Thank you. Through you, Mr. Mayor. So I don't have the setback. I'm sure Mr. Davidson might in his head. I don't have the setback, but looking at it was quite significant. So currently the shoreline setback is 30 meters for brand new development that doesn't have previous permissions. And where it does, we already have a zoned land that is just vacant and has like a residential zone on it. It would be 15 meters from the high water mark. So wherever that high water mark is. And so in every property, it's a little bit different because it's a high water mark is more of an elevation point. So at that 177.9 elevation, GSE, which is basically above sea level for the normal people that aren't experts. And so in this particular case, that's quite a ways away. I did look at a quick sketch and it was quite a ways. It's way below the slope. So we're not within that setback. So they're not asking for a setback reduction, more of just that building envelope change.
Any other member of council have any questions? Councillor Yuri?
Thank you, Mr. Mayor. Did the HSM do anything similar with parcel 5 when they had their permission granted?
No, they definitely did not. We're starting to see, and I'm starting to see, I can speak from my own experience, comments like this come up from time to time. The Métis group are being more active, and I got to be careful here. But again, the projects that I'm working on, they're making comments, but again, they're not really backed by any formal review. If this was Saugeen Ojibwe Nation, they would ask that a peer review be done. They would hire the experts to do it, and my client would pay for it. And 10 out of 10 times, you have to agree to that, and so it's done. But the Métis group hasn't been doing that. They've been just quite often lately with some of my files saying, we don't want to see this approved. And so it's really hard for me to stand up here and argue against that. I mean, because I don't know what I'm supposed to argue against, I think that's a fair statement.
Councillor Greenfield and then Deputy Mayor.
Thanks, Mayor Kentner, through you to Mr. Davison. The illustration to me, the illustration on page 5, showing the potential building envelope, and the illustration on page 9, the one on page 5 looks quite a bit more sizable. I wondered as I read through this, is the one on page 9, was that just being extra conservative as far as or has has a revisit been done on this site to perhaps expand that development area?
Sorry, go ahead, Denise.
Thank you, Mr. Mayor. I did go through the original subdivision file briefly today, and there were a number of documents in that subdivision file that are in that 2004 era when the zoning amendment was done. There's tree preservation, there's hazard setbacks and things like that. And some of it was just following slopes that existed or a setback from a slope. And so I would suspect it was based on a conservative estimate because there was very limited study to determine anything different. So there wasn't a slope stability study at that time. And so therefore that building envelope on these two particular side by side are quite small if you look compared to some of the other ones further down the road or even the one beside. So I suspect it's because the data wasn't there at that time.
Any follow-up or?
I'm hoping the zoning doesn't depend on high water, low water, because we all know Georgian Bay water levels vary considerably. I'm hoping it pertains to much more than just the high and low water levels, which we see every few years.
Deputy Mayor, you have a question?
Thank you, Mr. Mayor. Yes. Ron, I just wondered if I could ask, and Denise, you'll want to chime in, I'm sure, in relation to the comments expressing concerns from the Métis, thinking of their ability to pass comment on the shoreline aspect of this request for a zoning bylaw amendment. What really is the impact of that on the process going forward? Does their concern have to be dealt with?
Okay, and Denise, obviously, like you said, can back me up on this. So if, for example, Denise comes back or Michael comes back with the report for approval and council approves the zoning bylaw amendment, there is a 20-day appeal period. Neighbors can no longer appeal under the Planning Act, but agencies can. So there would be an opportunity for the Métis group to appeal this to the Ontario Land Tribunal. Now, when we get to the Ontario Land Tribunal, it would be, I guess, my side, if you will, which would be the engineer and myself and lawyer, and probably, I don't know if the municipality would defend its position. If not, Michael or Denise would be subpoenaed. If assuming staff are on side. And the Métis group, where I'm going with this is the Métis group, they would have to defend their position, and you can't just say, we feel that line shouldn't be shifted. They're going to have to call in an expert, either like an engineer of some sort, a coastal engineer or whatever, to defend that. And I like to work with people, obviously, because we don't want an appeal. Nobody wants that, and it is my nature to work with people. But again, though, these are too general of a comment to respond to. And like I said, we're seeing that more and more often. It's just, no, we don't want that. So that's not going to be, in my mind, that's not good enough as an argument at the Ontario Land Tribunal.
Councillor Forder.
Thank you again, Mr. Mayor, through you. My questions with regards to GSC's recommendation for the permitting. Is this something we need to add as a condition to the approval, Denise, or is this something that's automatic? Can you walk us through that, please?
Absolutely. Thank you. Through you, Mr. Chair. So it's automatic because a GSCA permit would be required anyways. I believe for most of this, they were the ones, I'm assuming I haven't looked at the regulated area, but with it showing as hazard in the official plan, I suspect that their entire property is regulated. Yeah, so that's confirmed by Mr. Davidson, but that's what I would expect whenever I see that much hazard in an official plan designation. So I don't think we need to add it as a condition. They've already kind of said that it's their support's conditional on that permit process. But I don't think we need to add any conditions to the approval in that regard. And but we'll bring back a little more information about that in the staff report.
Don't see any further questions. Okay, Ron, do you have any final comment?
I do not. Thank you.
Okay, then I'm going to move along. We want to thank you for attending this meeting and sharing your thoughts on the application. This matter will now be referred back to Planning Services to follow up on any additional information required from the applicant based on the matters raised today. Once staff are satisfied that they have all necessary information needed to provide a recommendation on the application, a detailed planning report will be brought back to council to assist us in our decision-making. This report will evaluate how the proposal does or does not satisfy the provincial, county, and Meaford policies that must be considered as part of council's decision. It will also explore the various public and agency comments received regarding the application, noting those tools which may be applied in order to address concerns raised and to mitigate potential impacts on nearby properties. If anyone would like to receive notice of a future decision on this file, please provide your contact information to the Planning Services Division by email, and you can do that at planning@meaford.ca. And with that, I'll declare, I beg your pardon.
Sorry, through you, Mr. Mayor. We have to do the confirming bylaw, so I need a mover and a seconder.
Okay. And mover and a seconder. Moved by Councillor Urick, seconded by Councillor Greenfield. Have people seen the confirming bylaw? They're all the same. And it is underlined by the fact that by signing it, I will not exercise my power to veto this bylaw. You ready to vote? All in favor? And that is carried unanimously. Thank you. And with that, I'll declare today's meeting adjourned.